Want me to be present, not distracted?
I don't think we're muted yet.
Huh?
Hi.
Hi, everyone. Hey, friends. Welcome. Super fun to see so many people I know. How are the Zylstras? Cold? It's very cold here.
Yes, you hit it on
What is it there?
25.
Okay, it was 14 today. Like when I went out today, it was 4. I know, Rebecca.
Your own fault for living there. I'm just saying.
I know. I was doing a coaching session today, and one of the girls was wearing like a tank top. I was like, oh my goodness, as I'm sitting here with my blanket and whatnot. So super fun. I'm just gonna wait for a couple more minutes to get everybody in. Thank you so much.
Believe it or not, 43 here in Orlando.
It's what in Orlando?
43.
43. Ooh, that is cold there.
I got you beat because Mrs. Coe and I are in Texas, and it is 50 degrees over here. So
yeah, you guys are probably really feeling cold right now with 50. That's so funny. That's so funny. Well, I'm super glad to see so many of y'all hopping on. We are super excited to be here. I know many of you guys probably have questions. I think one of the biggest things that I often hear about parents and coaches is, how am I supposed to judge something I don't know much about? And I am here to say you are all capable, and Ethan is going to help us feel maybe a little bit more equipped. And so I'm super excited that y'all are here. I will also tell you that Lasting Impact is so blessed to come alongside parents, students, and coaches and clubs, and it's really honestly a passion of ours. And so I'm super blessed to have Ethan be willing to just come alongside all of us. So thank you so much for spending the time to learn a little bit more about Moot, and really trying to give back to the students who have, I will just tell you, are already putting so much time and effort into their season. So thank you so much. I'm going to go ahead and hand it over to Ethan. If you have questions, feel free to put them in the chat. I will tell you, most of my life is, well, part of my life is on Zoom, and Zoom is my friend. I love it. I don't mind it whatsoever, because I feel connected, and it's so great to see you guys. I will tell you though, it is so much easier on Zoom when we can see your faces. So, and hey Adrian, how you doing? You're like in 2 different rooms. It's so fun. So if you don't mind putting on your video, because we really do, communication is a visual thing. And so being able to see you guys, I know for Ethan, it will be super helpful, if you guys are like this, that will help a lot. So, so thank you again. And I hope that you enjoy the evening. Thanks.
Heather, and I'll echo what Heather said. Thanking you guys. My mom, I invited her to join this. I don't know if she's going to join this, but she has been terrified of judging Moot Court for the last couple of years, because as a parent, when you're dealing with legal issues, especially stuff where the students know so much more about it than you, it can be really difficult to jump right in. So my goal for this session is to have you guys be a little bit more equipped and feel more confident in your judging. And I've had many parents come and ask me what I recommend for learning more about the packet without having to read, hundreds and hundreds of pages of case law. And that's what this session is for. So a couple things to start out with. Introducing myself, I am Ethan Tong. I am a 2019 NCFCA alumnus. I went to Hillsdale College for undergrad, graduated in May, and am at Truett Theological Seminary in Waco, Texas right now, pursuing my Master's of Divinity degree. I am the founder of Blackstone Moot Court, and we're partnered with Lasting Impact to get this session to you guys. Blackstone has been operating for 4 years now. In the last 2 years, I'm about to hit my 150th coaching session. So done a lot of coaching with Moot Court. It's been a lot of fun. I love it. One thing that I wanted to say about this session before we get in. First of all, some of you may end up not judging Moot Court. You may be participating in this webinar, but may end up that this is not the thing for you. If that is the case, I think you'll still benefit from this webinar because my job is to inform you, and some of the issues that we're talking about are very timely cultural issues. Talking about freedom of religion, we just had a big case last year about a coach who wanted to pray on field. That has to do with freedom of religion. This past summer, we had a case about a free speech, a web designer who didn't want to make wedding websites for couples that violated her conscience. So these are timely issues in our culture today, and the more informed we are, the better we can participate in our cultural discussion. So it will be beneficial for that as well. This session is going to be fairly fast-paced because we're covering 2 issues in addition to the facts of the record in under an hour and a half. So it's going to be pretty fast. So you're going to need to buckle in. I will do my best to be slow anyway, and I will try to not flood you with information, but it will be fast-paced. Ask questions as they arise. Feel free to unmute and ask them because sometimes I may not be able to see you on screen. You can also just drop them in the chat as well. Just ask questions as they arise, and then I'll have a little Q&A at the end so that we can open it up for questions that maybe didn't fit in during the time that we have together. Oh, fun. Okay, so I learned this from Hillsdale. Socrates actually says that you shouldn't take notes because you forget things when you take notes because it's really hard for you to listen. And when you externally write things, you put all your memory into the notepad and don't remember things afterward. I don't subscribe wholly to that idea. I think you should take notes, but I actually wanted to suggest that you consider taking less notes than usual and exchange that for trying to understand the concepts, and if you have questions, asking questions. Because I find that with high-level material, writing down what I'm saying is not going to be as helpful as just sitting there and trying to absorb what is going on. So you might want to consider that, though. Take as many notes as you want. And then the last thing I'll say before we just dive right into it is that content is going to be more of the focus of this presentation rather than how to judge Moot Court. I'll spend a couple minutes at the end talking about how to do ballots. But the reason I'm going to focus more on content is because most people know how to adjudicate ballots, how to give people numbers based on how well they did. The tough thing is the packet, because there's a lot to cover in the packet. And I want you guys to feel confident when you go into the rounds that you know what's going on, that the students aren't speaking completely above your head. So the focus of this session will be less on the mechanics of judging and more on the content. With that being said, we're going to get right into it. So as always, interrupt me with any.
Oh yeah.
Okay, we're going to start with the First Amendment. So there are 2 issues in this packet. One has to do with freedom of religion, and the other has to do with.
So I'm not gonna say anything really funny for your parents, but
sauce.
Hey, somebody is unmuted.
I don't love cheese.
the new right here.
Maybe it's sin.
Well, yeah. Well, and a lot of people.
Wait, is that your game?
You gotta be honest, it's like, you know,
Wait, is your camera off? I was like,
Okay, thanks guys. Okay, so the first issue is First Amendment, and then the second issue is guns, the Second Amendment. So the First Amendment's text has 2 main prongs. So it says Congress shall make no law respecting an establishment of religion, which we typically call the Establishment Clause, because it says establishing. So no law respecting an establishment of religion is number 1. And then number 2 is the Free Exercise Clause, which says Congress shall make no law prohibiting the free exercise thereof. So there are two components to the First Amendment. And the first one that says make no law respecting an establishment of religion. What it typically just means is the government can't prop up one religion over another. So it can't say Christianity gets, so for example, this is a pretty common example. You can't say nobody's allowed to proselytize in a park and then allow a Christian worship band to have a concert at the park, because that would be respecting an establishment of religion. Christianity, which is an establishment of religion, you'd be respecting it over other establishments of religion. The second part of the First Amendment is the Free Exercise Clause, and that's much more self-explanatory. Congress can't pass laws that prohibit the free exercise of religion. So on its face, it seems pretty self-explanatory, except for this question. So it seems pretty absolute, right? Congress shall make no law that prohibits the free exercise of religion. But what if you have a case like this? This is my horrendous drawing of an altar and a baby on it and fire. Okay, so you got a Satanist who's sacrificing their child. Crazy. Now what do you do with the First Amendment? Because the First Amendment says Congress shall make no law prohibiting the free exercise of religion. If you got a Satanist who says it's my free exercise of religion to sacrifice my child, how do you prevent that from happening under the First Amendment? That's the kind of question that First Amendment scholars need to answer. Where do we draw the line? Because of course we all want to say Satanists shouldn't be allowed to sacrifice their children. And we also want to say we should be allowed to go to church during COVID. So how do we draw the line in a way that is constitutional, where we're not just approaching it as Christians, but as jurists, as people who want to be faithful to the Constitution? There are two options that have been proposed, two tests. So if, let's say that, there's a person doing child sacrifice in Texas, God forbid Texas goes down that route. But if this happens, then Texas passes a law that bans child sacrifice. Okay, now the Satanist, being a terrible person, decides that they want to pass this law anyway. They want to be able to, they don't want to pass the law, they want to be able to sacrifice their child. So there are two tests that we can use to determine if the law is valid. There's a strict test and there's an easy test. And honestly, you could think about it in terms of like a boy trying to date your daughter. I'm sure you never have to deal with any of this craziness, but just imagine that there's, a boy trying to date your daughter. You could either give him the strict treatment where you say you have to fulfill like 100 criteria in order to date my daughter. You have to want to have 12 kids. You have to want to homeschool them. You have to be, think the election was stolen. Just kidding. I won't get into politics. So all of those things are a list of criteria that you could have for the boyfriend. That's a strict test. Alternatively, you could have a really easy test. As long as you don't, cheat on my daughter, you can date her. Those are the two tests. So those are the two tests. I give that humorous example, but those are the two tests that we use in First Amendment jurisprudence as well, where we ask if we're trying to pass this law. So this is like the boyfriend, right? The law is the boyfriend. And we're trying to pass through the dad. What kind of dad are we going to put out there? Are we going to put out a strict dad or an easy dad? And that's kind of the debate that people are going to be doing in the rounds this year. So the petitioner this year, who is representing the religious person, they want what kind of test? The strict test. Because the petitioner, if the law is going to ban, so I mean, if I were to make this more benign, let's say it's not child sacrifice. Let's say that it's like the law bans, let's say, drinking wine. And Catholic people who use wine as part of the Eucharist are going to say, well, we don't want that law to pass because then we cannot practice the Eucharist. So they want the test, they want the dad to be a strict test. They want it to be a rigorous test. That's what the petitioner wants, the religious person. The respondent always represents the government. And the government wants the easy test because they're the ones trying to pass the law. They're trying to get this law through. So of course they don't want a hard test. They want an easy test to try to pass. So what you'll hear this year is the petitioner is going to say, we want you to apply strict scrutiny. That's what it's called. The strict test is called strict scrutiny. And it's literally, whoa, I can't spell. And it's literally, the word scrutiny is what it sounds like when someone's scrutinizing you. Then the easy test is called the rational basis test. And I'll explain more about these tests later. But what you're going to hear, the petitioner is wanting you to use a strict test on the law because they want the law to fail. They want to be able to practice their religion. So they say, please implement a strict test. And the government, the respondent says, no, go easy on us. Give us the easy test. So that's what we're dealing with this year. Okay, so currently, do we usually go with the strict test or the easy test? Which one do we usually go with? That comes down to the most controversial case in First Amendment history, which is employment division versus Smith. And here's how this applies even outside of our context of moot court. This also just applies to religious freedom in general. I worked at a religious freedom firm, and they really didn't like Smith because Smith is not great for religious freedom. But this is the current law of the land. So employment division versus Smith was passed in 1990. And what they said is, usually, you get the easy test. So they said, if the government wants to restrict your religion, usually they only have to pass a really easy test. What they specifically said was, if the law is neutral and generally applicable, then it only needs to pass the easy test. So let's give an example. What do I mean by neutral? It's exactly what it sounds. It means that it's not targeted towards a particular religious group. So if I have a law that says, okay, think about the wine law. So let's say that Texas thinks that people are drinking too much. And so they pass a law that bans alcohol. That law happens to burden Catholic people's religious exercise because they can't practice the Eucharist anymore. And if any of you are Catholic or no Catholics, that's a central component of the Mass. That is the central component of the Mass. So that strongly burdens your religious exercise. So Smith says, if it's neutral and generally applicable, it only has to pass a really easy test. So let's ask the question, do we think a law that bans wine or alcohol is neutral? I think so, because it's not trying, assuming, because Texas, we said, they just don't like alcohol. They don't like people getting drunk. So they don't hate Catholics. They're not like anti-Catholic. They just don't like alcohol. So is the law neutral? Yes, the law is neutral. Is it generally applicable? Does it apply to everyone? Well, yeah, nobody can drink wine. Nobody can drink alcohol. So according to Smith, which is the current law of the land, a law that bans wine, bans alcohol, gets the easy test. So now you can see why a lot of religious freedom activists do not like Smith, because Smith said that if the law is not trying to hurt anyone, if it's not targeted towards anybody, then it's going to get a very easy test. So the people who are opposing Smith want it to be overturned. And if Smith gets overturned, and if you reverse employment division versus Smith, instead, so if you overturn, you would usually, or actually no, not usually, you would always get the strict test. So if you overturn employment division versus Smith, then this neutral and generally applicable phrase right here means nothing. It doesn't apply anymore. And so every law that burdens religious exercise, even if it's not intentional, is always going to get a very strict test. It's going to get the strict dad, which means it's probably going to lose. Because in most cases, if you're getting a strict test, you're going to lose. It doesn't mean in all cases, but in most cases. Okay. Any questions about Smith so far?
Just a question, Ethan. When
Yes.
you said it's the current, you said that Smith is the current law of the land. It's not a law in the sense that it was passed by Congress, but it was a ruling. Is that right?
That's correct. Good clarification. We still refer to Supreme Court decisions as the law of the land, but you're right, it was not passed by Congress. It was a decision by the Supreme Court. Yes.
Thank you.
Yep. Okay. So here's the situation. Here's where we get to the fun part, the Paladosa law. So this is the specific case. So you get a fictional case that the moot court students have to deal with, and they're presenting this fictional case in front of the court. So there's a fictional state called Paladosa, which is the 51st state in the Union, and it borders on Mexico. Paladosa has a problem because a lot of people like to use psilocybin, which is a I was about to ask if anybody knew, but I don't think anyone would confess if they knew what psilocybin was. Psilocybin is a psychedelic mushroom, which is a hallucinogenic, so it allows you to interface with your higher being, as some would say. And so there's an increasing use of this psychedelic mushroom in the state of Paladosa. In particular, there's a church called the WWC, which stands for the Wild Weedville Church. And the Wild Weedville Church uses psilocybin as part of their religious services. By the way, this is actually based on a previous case in which there were Native Americans who used peyote, which is another drug, as part of their religious services. So it is not out of the question for people to use drugs as part of their religious service. So the Wild Weedville Church uses these psychedelic mushrooms as part of their religious service. And a lot of people don't like that. And so Paladosa passes a law, House Bill 831, doesn't matter if you get down the words, but the law bans psilocybin for everyone, almost everyone. We're just going to say for everyone for now. So psilocybin cannot be used. Okay, so let's ask the question. Is this law neutral and generally applicable? Because we said if it is, what kind of test does it get? It gets the easy test, the test that the government can usually pass. Like it's a really low bar. Is a law that bans psilocybin for everyone, is it neutral? Probably, right? I mean, it doesn't seem like it's targeted towards anyone. They just don't like people using the drug. Is it generally applicable? Does it apply to everybody? Yes, right? It applies to everybody. So according to Smith, it seems like this law should get the easy test. And if it gets the easy test, it's probably going to win. So this law passes according to the current law. Now, we don't like this. The Wild Weedville Church doesn't like this in particular because they want to be able to practice their religion. Because if they're not allowed to use psilocybin, which is the centerpiece of their service, then their church is meaningless now. And so they petition their case to the Supreme Court. And that's where we're at. So the petitioner technically is named Kobe Mendax, and he serves at the Wild Weedville Church as one of their, he gives them their communion for when they drink some tea brewed with psilocybin. And he's the person that gets caught with these mushrooms. And so since he's in violation of the law, he gets sent to jail. And he says, well, this is part of my religious freedom. And so this case gets petitioned all the way up to the Supreme Court. Okay, so there are two cases that the petitioner is going to run. So these are, I put these in quote marks because if you've judged team policy, they're really like TP cases. They're two different options for getting you to affirm the resolution, or in this case, to side with the petitioner. Both of these cases you may see throughout the year, but you are not going to see both of them at the same time usually. You're just going to see case one or case two. Both cases get you to the same place. Because both cases, we said on petitioner, do we want the easy test or the hard test? We're the Wild Weedville Church. Do you want the easy test or the hard test? Well, you want the government law to have to pass a lot of restrictions. You want them to pass the hard test. So as we said here, the petitioner always wants the strict test. So this year, you're going to hear two cases that are going to try to persuade you to apply the strict test, strict scrutiny, which is SS up here, strict scrutiny, two cases. The first case is the simplest case, right? Overturn Smith. Because as I said earlier, if you overturn Smith, you always get the strict test. And if you get the strict test, that means that the government's usually going to lose because it's pretty strict. It's hard for them to meet the test. And if the government law loses and the law gets struck down, well, WWC can use their mushrooms again. So this is what the petitioner wants. They want you to apply the strict test. Okay, so overturning Smith. Why would you want to overturn Smith? it's not just, well, I don't like Smith, because that's not a persuasive enough argument. There are two main arguments. Argument number one for overturning Smith: it ignores the text of the amendment. So if you look at the text of the First Amendment, it says, Congress shall make no law prohibiting the free exercise thereof. It does not say, Congress shall make no law prohibiting the free exercise thereof, unless it's neutral and generally applicable. That phrase, because remember, that's Smith's famous phrase, neutral and generally applicable. That phrase is not in the Constitution. They put it in there. So the first reason why Smith might be overturned is because it ignores the text of the amendment. The second reason it might be overturned is because it ignores case precedent. I'm not going to explain a ton here because I want the Mooters to explain it to you, but Smith did not do a good job of respecting the cases that came before it. Because in general, as a Supreme Court, you want to respect the case that came before it, so everything is consistent that comes out of the Supreme Court. You don't want to like make a decision that's completely out of left field, because nobody will be able to predict the Supreme Court if everything's completely random.
Hey,
And
E, can I ask you a question?
yes,
So, if you're saying that the petitioner, who exactly is, so this is really basic, but who exactly is the petitioner? Are you saying that guy Corbin or whatever his name is the petitioner?
so Kobe Mendax is the petitioner, but the question is whether or not you should overturn the law. So he's the petitioner because he's bringing the case before the court. But the question is this law good or not?
But why? So, okay, so I'm a little confused. So why would he want a strict test? Because then that means that he might not meet that test in order to allow psilocybin to be used. I'm sorry, I'm not connecting the dots.
Good question. So he doesn't want the test for him. So the test never applies to a person. The test always applies to the law. And the law is being proposed by the government. So he wants the government to have to pass a strict test because the government's probably going to lose. If they have to meet a lot of hard criteria, they're going to fail. So he's asking for the test to be applied to the government because that's what the test always gets applied to. Does that make sense?
Yeah, okay. So then he's saying that the government will probably not be able to pass that test and therefore will not be able to create a law against psilocybin.
Yes, that's right. Good.
Okay, got it. Thank you.
Yeah.
So the petitioners are actually trying to overturn the Supreme Court case. Is that so?
Yeah, they're asking the court to do so. And we've seen the Supreme Court overturn cases before. I mean, many of you are familiar with the court's overturning of Roe v. Wade in Dobbs v. Jackson, in which they overturned their decision in Roe v. Wade. So what the petitioners in this case are doing is asking the court to do the same. They're saying overturn Smith because it was a really bad decision, just like Roe v. Wade was. And as I'm saying, I'm not going to explain too much about how it ignored case precedent because I want the debaters to do so. But I want you to listen because if Smith did a bad job of addressing precedent, it's probably a bad case. And so that's the argument from the petitioners. Now you might be wondering, man, Smith sounds like a really bad case. Why was Smith ever written? Who decided Smith? To which I say, I agree with you. I have no idea. That's not true. There are a couple of reasons why I think Smith is a valid case. First of all, so this is against Smith. So I'm going to say con Smith. So I'm going to say pro Smith. This is a little bit harder for me to articulate because I don't think Smith is super defensible. But they have a different reading of the First Amendment. So they would not say that they're ignoring the First Amendment. They're saying they have a different reading of it. So let's take a look at the text again. Congress shall make no law prohibiting the free exercise thereof. Justice Scalia, a famous conservative justice, all the conservatives are very upset that Justice Scalia crossed the aisle to write this very poor decision for religious freedom. But he wanted to make the argument that the word prohibiting sounds like it has intent behind it. Like I'm prohibiting you. If, for example, I'm standing in the door frame and I mean, I'm not that large, but I'd like to think that I'm pretty muscular. And so you can't get out of the door because I'm such a big guy. If I'm not facing you, so I didn't even know you're trying to get past me, nobody would say that I'm stopping you, I'm prohibiting you from crossing the door. Because if you tap me on the shoulder, I'll just let you out. So Justice Scalia says, if it's neutral and generally applicable, it doesn't sound like you're trying to prohibit someone's free exercise of religion. So it all hangs on this one word, prohibiting. What do we mean by prohibiting? Is there intent behind it or is there no intent? So take the wine example. If Texas's intent in banning alcohol was to stop people from getting drunk, that they don't hate Catholics, they just don't like drunk people. Scalia says, doesn't seem to me like they're prohibiting the free exercise of religion. It seems to me like it happens to inhibit them, but they're not actually actively prohibiting it. Think about that, because do you think that that reasoning makes sense? Maybe so, maybe not. And I want you to evaluate that reasoning, because that's the kind of reasoning you have to listen to when the debaters, the mooters, are discussing the text of the First Amendment. What do we mean by prohibiting? Here's another example. Let's say that there's a really crabby judge, an old codger, this traditionalist, let's say that he's, 70, 80, gun-toting conservative judge. And he just can't stand all these kids coming into his courtrooms wearing flip-flops and shorts and baseball hats with their middle parts and pinging themselves on Discord. He just can't stand these kids in his courtroom these days. So he asks the city to pass a law that says nobody can wear flip-flops, shorts, or hats in my courtroom. That's his intent. If you're a Jewish person, how does that affect you if you're a Jewish man? You can't walk into courtroom with your yarmulke. Was the judge trying to prohibit you? No, he just cared about the younger kids. But did he end up prohibiting you? Yes, because you can't wear your yarmulke in his courtroom, which burdens your free exercise of religion. So Smith says, what test gets applied to the judge's proposed law? The easy test. Because Smith says, if it's neutral, it gets the easy test. And is the law neutral if it says, if they're not trying to, if they don't hate Jewish people, if it's not anti-Semitic, is it neutral? Yes, of course it's neutral. So it gets the easy test according to Smith. Opponents of Smith say, okay, so you really want to restrict Jewish people from wearing their yarmulke in court? That sounds like it violates the First Amendment to me. And again, Smith is going to say no, because they didn't prohibit. They weren't trying to prohibit. I don't look at the law that says no hats in the courtroom and say, man, that judge really hates Jewish people. That judge really hates Sikh Muslims. I don't read it like that. And so Scalia says, okay, it happened to hurt their religion, but it wasn't trying to. Sorry. Second argument that you might make, that is in defense of Smith, is called stare decisis, which is a Latin term, which means to stand, stare, by things decided. All it means is I'm respecting Supreme Court precedent. We have had a precedent of Smith. So Smith is our precedent. Currently, this is the law of the land, Employment Division versus Smith. So we typically want to stand by things decided. Now, as you all know, because I assume many of you are pro-life, we shouldn't always adhere to stare decisis. We shouldn't never overturn a case, even if it was really bad. But here's what they're going to say, the pro-Smith people. It requires a special justification to overturn a case. You can't just say, oh, I'm going to overturn a case because I don't like it. Because could you imagine if, because currently we have a conservative supermajority on the court. What if it was flipped and it was 6 liberals and 3 conservatives? And the liberals said, I just really don't like a lot of the cases conservatives have made. And so they just overturn those cases. We'd be upset, right? And so the point of the Supreme Court is not to just say, I don't like that case, so I'm just going to overturn it. The point is, you have to have a special justification to overturn cases. So for example, one famous case that got overturned was Plessy v. Ferguson, that got overturned by Brown versus Board of Education. Plessy said, blacks are separate but equal. And Brown versus Board of Education said, that's racist and unconstitutional. So they overturned that decision. What was their special justification? Well, one, society was no longer trending in a very racist direction. Society was trending toward equality. Second of all, that decision abrogated the rights of substantial amount of Americans in a substantial way. So it was a very significant impact on Americans. So there was a special justification for overturning that case. So as you evaluate this year, don't just decide, okay, I'll overturn Smith because it seems wrong. You have to have special justification for overturning Smith. They have to give you a really persuasive case in order to make you overturn Smith. Okay, so that's number one, the first way that you could get the court to apply the strict test. And because remember, as we said, Toby Mendax wants this law right here to get a strict test because he wants the law to fail. So the petitioner could take that approach, or they could take the second approach, which says that the law is not neutral and generally applicable. Because look at what I said with Smith. So Smith said, if it is neutral and generally applicable, it gets the easy test. But Smith admitted if it's not neutral, it gets a strict test. So if the law in Texas said, we want Catholics to stop taking the Eucharist, even Smith would say that should get a strict test because that law is pretty bad. It has to pass a lot of muster. Because if it's overtly trying to prohibit your religion, then that should get the strict test. So the second option is, I don't want to overturn Smith because I don't think I have special justification. So what I'm going to say instead is that the law is not neutral and so it should get strict scrutiny. What are those arguments? How could you say it's not neutral? Because it seems pretty neutral, right? It says nobody can use psilocybin, so it seems pretty neutral. Henry, got a question?
Yeah, can you describe a little bit more about special cases? Like what's the special justification?
Yeah.
How do you know this is the right case and not a future case?
This is great. And unfortunately, I can't give you a straight answer because that's the role of jurists on the Supreme Court. We don't have a strict test that's like, if it has violated 5 case precedents and 7 justices hate it, then you can overturn it. It really is, it's the same thing as in courts of law, they say a reasonable person standard. What would a reasonable person think about X, Y, Z? And so I don't have a strong answer for the special justification thing because it really is up to you. Do you think they persuaded you that this case is in the same category as Plessy and in the same category as Roe where you can overturn it? Because if it is, sure, go ahead, overturn it. You can overturn cases.
But as a judge, I want to poke at them and test them. Why do you think this is the right case to do that?
Yes, you can certainly ask them those questions, and you should. You should continue to prod them. You can't just tell me it's a bad case. You have to tell me it's an egregious case.
Okay.
Ethan, can I ask a question?
Yes, please.
So at the beginning, when you were talking about the neutrality, you mentioned Texas and alcohol, and wine is a sub-segment of alcohol. But then when you mentioned the second one regarding that specific drug, you were very specific about that exact drug. And so to me, my thinking was, well, you're not talking about a generic thing like hallucinogenic drugs. You're talking about a very specific drug that's only used by one religion, if you will. And it kind of seems to me that you're targeting a group if you're getting that specific. Is there any validity to that?
Yes, thank you for bringing that up. This is great. This is actually what I want you guys to be thinking about, because that is exactly what this second case is going to argue, is that it seems like it is not a neutral law. It seems like the law is targeting the people in the Wild Weedville Church. Now, I will push back on you on a couple of areas. First of all, there are people outside of the Wild Weedville Church who use psilocybin. So you'll see if you read the facts of the record that psilocybin is a drug that is in the same category as heroin and cocaine, and it is classified as a Schedule II drug, and it's a newer drug, but a lot of kids are using it, and a lot of people in general are using this. It happens to be used frequently in religious services, but it is not exclusively used by the church. But how is this? How could the petitioner argue it's not neutral? What the petitioner would say is, well, first of all, there is a lobbying group called Mothers Against Magic Mushrooms, MAM. And this lobbying group said, we don't like that people are using psilocybin in religious services. Please pass legislation to ban that. But and so this lobbying group is trying to push for psilocybin to be stopped, including in religious services. Now, that doesn't mean that the law itself is not neutral, because as you know, lobbying groups do have some power, but they don't necessarily, they're not the ones who are passing the law. And so what we need to ask is, are the legislators, are they neutral, or are they targeting the Wild Weedville Church? The evidence for that comes, one piece of evidence. There's one piece, and it's in footnote 3, and it says there are 2 legislators. And both of them said they're concerned about the overall use and the use in churches. Okay, just based on this phrase alone, does this strike you as they don't like the drug or they don't like the church? Just think about it, because that's going to dictate if you agree with the petitioner here or not. You can read the footnote for yourself, and you'll hear the Mooters explain this to you, because if they want to run this case, the second case, they're going to have to persuade you of this, that the legislators don't like the use in churches. Because if they don't like the drug, that's not targeting a church, that's targeting the drug, and that's okay. The only problem is when they target the church.
One of the legislators tried to apply for religious exemption, but it failed, right? Yeah.
Yes, so footnote 3 also mentions, as Henry's pointing out, there was a legislator who was actually pro-WWC. They actually supported the WWC. Also, you'll know how many legislators, maybe you don't. Texas has like 150 legislators in their legislative body. Are 2 legislators enough to prove that the whole body didn't like the Wild Weedville Church? Maybe, maybe not. So think about these kinds of questions. Those are the questions you want to prod the Mooters to prove to you. Prove to me that that the legislature as a whole had anti-religion animus, that they really didn't like religion. Okay, that's not neutral. What about generally applicable? I told you that the law says it bans psilocybin for everyone. That's actually not true. It says everyone except people in the medical community. Uh-oh. This seems to be possibly problematic, because it actually says you can use psilocybin in a medical context. You just can't use it in a religious context. And that seems to be problematic because it has to be generally applicable. And here, the Mooters might quote the case of Fulton, in which Fulton says, if the state has a system of exemptions, they cannot withhold it from religious people. Oh man, so you might think, oh dang, at this point, this seems like a really strong case, because they have us exceptions, but they didn't give it to religious people. Isn't that a slam dunk case? Except that there's a little phrase tacked on at the end of this quote that you need to make sure that the Mooters say to you. It says, without compelling reason. So you cannot withhold an exception unless you have a reason for withholding the exception from religious people. And think about it. What might be the reason for giving an exception to licensed doctors and not giving an exception to random people at a church? Well, one is monitored, protected, oversight. There's regulation. The other one is unmonitored, no oversight, no protection, no regulation. That seems to be a compelling reason to me. So yes, it's true that there's an exception for medical reasons and no exception for religious reasons. But if you have a compelling reason, you can do that. And I think that there is a compelling reason here, possible.
What about the least restricted means?
You're jumping ahead of us, Henry.
Oh,
So
sorry.
I'll get to that. No, this is a fine question. We'll get to that because that's one of the prongs, one of the elements of the strict test that I was telling you about. We'll get to that. Good question. Okay.
Ethan, overall, as I guess as a justice, as you're asking the Mooters questions, you've mentioned a couple of times, even in the Supreme Court, right? There's conservative and there's liberal justices. Are you supposed to start this round to try and be as even keeled as you can, like not having a preferred side, or as a justice, can you have a preferred side and be, I don't know how to ask that any better.
Yeah, that's okay. You can't entirely eliminate all your biases. What you should try to do is be as fair as possible in terms of your adjudication of the ballot. So if you tend to think that the petitioner is right, that's okay. You can tend to think that the petitioner is right, as long as you don't adjudicate the ballot and just give them 50s just because you think that they're right.
Right.
You just evaluate them on the arguments. But I don't think, you shouldn't be scared to have beliefs. It's just you shouldn't let that seep into your ballot. That's what I do.
Okay.
Okay, actually, Henry, I will address your question now because we're going to move on to the Second Amendment in a second. So I said that there's a strict test and an easy test. So the strict test has two prongs. One is the government must have a compelling interest. What does that mean? It means that whatever my reasoning for passing my law, it has to be a compelling reason. So if my reason for banning psilocybin is I don't like the smell, that's not very compelling. What is compelling is if I say I want to ban psilocybin because it promotes public health and safety. I want to stop people from overdosing. I want to enforce the drug laws evenly. Those are some compelling reasons. So the state has to show a compelling reason, not a small reason. Number two, it has to show that that their law is the least restrictive means. So they have to show that whatever their law is the least restrictive way of achieving their interest, So think about psilocybin. My law bans psilocybin except in medical use. Is that the least restrictive way that I can promote health and safety? If you think it is the least restrictive way you can still keep promoting health and safety, then you think that the law passes strict scrutiny. If you think there are less restrictive ways, then it doesn't pass strict scrutiny. And let the mooters explain these arguments to you. But again, don't worry about the technical terms because ultimately the real question is just, should it get the easy test or the strict test? Because in almost every case, if you get the strict test, you lose. The government loses. This is like, if you talk to any lawyer, they know strict scrutiny is the highest burden in the criminal, in the jurisprudential field. It's the highest burden. And so if the petitioner can prove to you that they should apply the strict test, they're probably going to win. The easy test is the opposite. If the respondent can prove to you that it should get the easy test, the rational basis test, they're probably going to win. They don't really need to prove it to you because it's probably going to be fulfilled. But I'll explain the prongs of the rational basis test. So instead of compelling interest, it needs to be a reasonable interest, which is much lower. In fact, somewhere in between is an important interest. So it doesn't even need to be important. It just needs to be reasonable. And the second prong is it needs to be reasonably linked. The law needs to be reasonably linked to the interest. Reasonably linked to interest. Again, don't worry if you're like lost here because this doesn't matter as much as do I apply the strict test or do I apply the easy test? Because in most cases, if you apply the strict test, government loses. They very rarely, they can, but it's very rare. I'll give you an example of where the government would pass the test. So I talked about the Satanist and the child sacrifice. So let's say that we applied strict scrutiny, which means the government usually loses. Their law says we ban child sacrifice. What's the compelling interest? Protecting kids from dying. Is the law that bans child sacrifice the easiest way to prevent kids from dying? The least restrictive way to prevent kids from dying? Yes, there's no other way to prevent kids from dying other than banning child sacrifice. So is that law going to pass the strict scrutiny test, even though it's a really high bar? Yes. But that's a pretty rare instance. In most cases, government loses if it's strict. Does that make sense to everybody? Strict test, government loses. Easy test, government wins, usually. Okay, we're moving on to the Second Amendment. And again, I'll open us up for Q&A. So if you have any lingering questions, we can address them later. Okay, the Second Amendment says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, many of you know the second part, which is called the operative clause, because this is the operation operative clause. Not many of you know this first part, which is called the prefatory clause, as in preface. The prefatory clause, does this bother anyone? Because if you've never read the Second Amendment, you didn't realize that it mentions the military, that it actually says, since a military is necessary to having a free state, the right of the people to keep and bear arms shall not be infringed. Uh-oh. Okay, so how do I respond to this one? So we actually have a whole Supreme Court case about it. That was the case in DC versus Heller. There are only 3 Supreme Court cases in our entire history about the Second Amendment. The very first one was in 2008 with DC versus Heller. DC versus Heller, they decided the prefatory clause announces a purpose, but does not limit. Does not limit. Why is that? Well, think about if I said a well-rounded spiritual human being being necessary to your development as a human, all Christians should go to church. So I'm announcing a purpose of why you should go to church because you're a well-rounded spiritual being. Is that the only reason why you should go to church? Of course not, but it is a reason. And so the court said, it is true that the first part announces the purpose of the second part, but it's not the only reason. And so it does not limit the reading of the operative clause. The operative clause should still be read strictly. The right of the people to keep in their arms shall not be infringed. You can feel free to ask the students this because they should know the answer to this question, even though it's not a question about Mendax strictly. But they should know this because there are only 3 cases to know about the Second Amendment. And this is a really important pedagogical thing for them to know. Okay, the same thing with the First Amendment. So the First Amendment doesn't say any exceptions, but there still are exceptions, right? So it doesn't say Congress shall make no law prohibiting the free exercise thereof, except for strict scrutiny. It doesn't mention that in the text, but that's how we've interpreted the First Amendment. The same thing is true of the Second Amendment. The Second Amendment doesn't state that there are exceptions, but there are. And I mean, this is just true in real life, right? I know none of your kids would ever dare yell at any of you, but just imagine that one of your kids raised their voice at you and you said to them, you know, Ethan, don't you raise your voice at me. There's no exceptions in that, right? You didn't say, Ethan, don't raise your voice at me unless this. You just said, Ethan, don't raise your voice at me. Now, if my mom is texting and driving, which she never does, ever, and I were to say to her, Mom, because she's about to get into a car accident, and I raise my voice at her, I don't think she would be mad at me. This has never happened. I don't think this has ever happened. I hope that she wouldn't be mad at me for raising my voice at her if I were protecting her from dying. That's because even though she gave me a quote unquote absolute statement, we all know that there are exceptions baked into that statement. The same thing is true of the Second Amendment. Now, unfortunately for us, the test for the Second Amendment is not the same test as the First Amendment. So you have to think about a second test, but it's okay because they're compartmentalized, so it's a little easier. Fortunately, there's still 2 prongs of this test. This test was in the 3rd case. So this is case number 1. Case number 2 is called McDonald. This one is you do not need to know this one very much. Number 3 is a recent case. And if you are following the news, or were following the news last year, this case made headlines because in the same summer that the court overruled overruled Roe v. Wade, they made this controversial gun decision where they struck down a New York gun regulation, and they issued in this new test that have caused liberals everywhere to panic and to throw a fit. So here's what this new test is. Question number 1 in this test: is the person who is trying to own a gun part of the people? Because look at the text. It says, the right of the people to keep in their arms shall not be infringed. So the first question is he part of the people? That's Bruin's first question. Bruin's second question is there a historical analogy to the regulation that the state is proposing? That's a mouthful. So if New York is trying to propose a regulation, so here's what happened in that case. New York said, you cannot get a gun license unless you have proper cause. And they're like, you have to show special need for a gun. So unless you can show me that you live in a high crime neighborhood, have been assaulted, and have a special need for a gun, you can't get a gun. So that was their regulation. So question 2 of Bruin says, have we ever done something like this before? Is there a historical analog to this regulation that we're proposing? So New York wants to propose the proper cause standard. Have we ever done anything like the proper cause standard? That's the question. Now you might be thinking, why on earth did we choose that as the second prong? That seems like a very random prong. Because notice, there's no question about societal safety. There's no question about the people's interest. There's no question about life and death. It's just, is there a historical analog? Why did we do this? Well, in truth, it's because our court is more and more originalist, which is a phrase that means they want to interpret the Constitution according to how it was originally intended. And so they want to go back. So if I'm going to be charitable to our current Supreme Court, I would just say they trust the founders. They trust the framers. Because they say, if the framers approved of a regulation in the past, well, then they would approve of this regulation here. But if they didn't approve of a regulation in the past, they're not going to approve of one here. So let's scrap that regulation. Why all this talk about the framers? Okay, so the Second Amendment was written in the Bill of Rights, which was codified in 1791, 4 years after the Constitution was written. So the framers of the Second Amendment wrote this in 1791. People want to interpret it, the Second Amendment, according to our modern eyes. That's how a lot of people on the more progressive side want to interpret the Second Amendment, according to how we can interpret the Second Amendment. Why is that problematic for the court? Well, think about it this way. Let's say that your family has been having trouble bonding. And so the dad in your family says, okay, we're going to have a lot more fun with our kids. So I'm going to say, I'm going to draw everyone together for a family meeting, and I'm going to say, every Saturday, we're going to have fun. And I write it down on a piece of paper, everyone signs it. Now, you know that the dad's idea of fun is video games and watching sports. So every Saturday, your family plays video games and watches sports. Now, in some terrible universe, the father passes away, and the mom is now the head of the household. And she says, my idea of fun is gardening. This is definitely from personal experience. So if you have a mom who says, my idea of fun is gardening, she holds up the paper and says, guys, you signed it. You said you wanted to have fun on Saturdays. My interpretation of fun is gardening. And you say, what? When we signed it, we had an idea in mind. And so the reason why we care about historical analogs is deep down because we care about democratic legitimacy. When the people ratified the Second Amendment in 1791, when they agreed to that, they had a certain idea in mind. They voted because they knew what it meant. So if we insert our own opinion, instead of thinking about what they had to say, we're changing what their words were. We're interpreting fun as gardening instead of as playing video games and watching sports. If you wanted to, pass a new law, you could pass a new amendment that redefines the Second Amendment. But our current court says we're good originalists, and we want to interpret it as the founders would have interpreted it, because that's who voted on it. They agreed to it, so we should agree to what they agreed on. Okay, now we have to get into the details of this specific situation. So here, I'm going to stop screen, and this is a true multimedia presentation because we move to a different. Okay, so let's imagine this is Mr. Kobe Mendax. That's Kobe from Dude Perfect, if anybody doesn't know. Okay, so this is Kobe Mendax. He's 32, and he's married to his wife, Angelina Mendax, who is just quite a looker. And they live in the 51st state of Union Caladosa, which is down there. Okay, so let's take this specific situation. So this is the fictional case. So Kobe Mendax and Angelina Mendax are heard by their neighbors arguing in their apartment. Yada, 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 yada. And so the neighbors hear a loud thump, and so they call the police. They're like, what's going on in that apartment? So the policeman shows up to the door. He's like, hey, what's going on? After a few minutes, Kobe Mendax opens the door, and his wife appears behind him, and her face is red and swollen, and she's crying. So obviously the inference that you're supposed to make is it's likely that he beat his wife because her face is red and swollen and she's crying after an argument and a loud thump, right? So they take him to the police station and he bonds out later. Now, while they're waiting, the police officers decide, they get together with the state attorney general and they're like, hey, should we press charges? And the state attorney general says, I don't think there's enough evidence, so we're not going to press criminal charges. Before I move on, I want you to just stop and think about that. the state attorney general decided that they weren't going to press charges because they didn't think there was enough evidence. Okay, I'm going to let you just think about that. We're going to move on. So, no, any evidence? No, not enough evidence. Okay, moving on. So now Angelina Mendax comes in to the courtroom and she files for a civil protective order, which is also called a restraining order. And she says, my husband has been beating me. I would like to file for a dissolution of marriage. And also, I would like to, which by the way, dissolution of marriage is a no-fault divorce. So it's different from a divorce. So I don't know why she didn't apply for a divorce. Maybe she was afraid of him. But she files for a dissolution of marriage. And she asks for a restraining order on Mendax. So they, he comes in, the police officer comes in, and they all have a discussion about what happened. And the judge decides this is not a criminal trial, right? This is a civil hearing, not a criminal trial. And the judge decides, well, there's enough evidence for us to say he hit his wife. Because he hit his wife, he doesn't get his gun anymore, and he cannot meet with her anymore. So off she goes with her protective order, and he does not get his gun anymore. So now we're at the gun range, and Kobe Mendax is there because he really likes shooting his guns as a good old-fashioned Texan man. And boom, 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 he's shooting his guns in the gun range. And while he's shooting his guns in the gun range, there appears the police officer who knows he's not supposed to have guns because that's what the judge decided. So he hangs around the car and he catches Kobe Mendax in the act and he's like, hey, aren't you not supposed to have guns? And he's like, well, that's because my ex-wife lied. And he opens up the trunk and he sees in the trunk there are a bunch of psychedelic mushrooms, and that's how the two stories are merged, the mushrooms and the gun. Okay, I kind of ran through that fast because you could read it over if you wanted to in the facts of the record, but that's the general gist of what happened with Kobe Mendax. So, okay. So the question is, we have to answer these two questions about Kobe Mendax. Is he part of the people? And then, since the state of Paladosa says, if you get a protective order, you can't get a gun, is there a historical analog? As in, have we ever done something similar to taking guns away from domestic abusers? For people who are not convicted, but are suspected of domestic abuse. First question, is he part of the people? I am going to suggest to you that this is pretty much an open and shut question. He is part of the people. Now, some people are going to say, well, he's a criminal, and so he's not part of the people. He's not a criminal. He hasn't been convicted, right? And further than that, even if he were convicted, if he's not in prison, so Heller says, you're part of the people if you're part of the political community. So my question is, if he's not part of the Paladosa political community, what political community is he a part of? Because he's certainly not part of the Tanzania political community or the Hong Kong political community. What are the political communities a part of, if not United States? So is he part of the people? I think yes. That doesn't mean you get your gun. Just because you're protected by the amendment doesn't mean you always can get a gun, right? Because most of you guys are law-abiding citizens, so you can get a gun. That doesn't mean you can bring an AK-47 and point it at Joe Biden's face in the White House, right? So just because you have the right doesn't mean it's absolute. So then we move to the second question, which again is asking about the framer's intent. So here's how I draw this up. So we've got the modern regulation and the historical regulation. So the modern regulation here is if you have a PO, so if you're a PO subject, no guns. So the respondent's job, if they want to say this law is valid, the respondent has to show you a historical analog, because they're the government, right? They want to pass this law. So they're going to propose some historical analogs. The most common historical analog you're going to hear is surety laws. This is not the only one you'll hear, but this is a common one. And so surety laws were around the time period of 1838 to 1880 something. So about like the mid 1800s. Surety law said, if I'm afraid somebody's going to hurt me, so let's say that I'm afraid Erica is going to hurt me, I'm going to go to a judge and I say, hey judge, Erica is going to hurt me. I'm really afraid of him. And if the judge believes me, the judge is going to call Erica into his courtroom and say, hey, I believe that you're a threat to Ethan. So you either have to put down money as a bond, a promise, a bond that you won't hurt him. Because if you hurt him, I'm keeping that money. So put down $2,000, $10,000. I don't know, depends on how much you make. $10,000, and you'll get the money in 3 years' time if you don't hurt him. But if you hurt him, I'm keeping the money. If I say I don't have $10,000, I'm not putting that money down, the judge can order me to give up my guns. What are the similarities here between surety laws and PO subjects not getting guns? Similarities. Well, first of all, it's a judge. There's no criminal conviction. So you just appear before a judge. Second of all, person afraid of another person. So I'm afraid of Eric, just like, or Eric is afraid of me, just like Angelina Mendax is scared of Kobe Mendax. So judge, person afraid of another person, no criminal conviction. Now, if you're doing some critical thinking at home, you know that there's a big difference between surety laws and this. The big difference is, anyone thinking of it? Spit it out if you can think of it.
Bond?
Yeah, the bond. That's huge. That's huge. Why is that huge? Because in surety laws, you could have your gun. So I'm going to say conditional removal of gun. And this is an absolute removal of gun. Oh man, that's pretty big difference, right? In one case, you could have your gun taken away if you don't put down the money. And the other, you can't put down money and get your gun. You just don't get a gun at all. It's just slam dunk, case closed. So your job as the judge is not to answer, are these identical? Because they will almost never be identical. In some cases, I guess, hypothetically, they could be. But in most cases, since this is in 1791 era, and this is in 2023 era, they're going to be very different. So your question is not, are they twins? Not, are they dead ringers for each other? Your question is, are they, and this is the court's words, and Bruin is the big case. Remember, we said that this test, this two-part test comes from Bruin. Okay, so Bruin says that they just need to be relevantly similar. So your question for the mooters, are these two things relevantly similar? They don't need to be identical, they need to be relevantly similar. Okay, and as I mentioned, this is not the only analog. People could propose a different one. So they could propose, for example, a law that there was a ancient going armed law. So I'm going to say going armed laws. And those going armed laws says, if you're going out to terrorize other people with your gun, the judge can take away your gun. Same thing, right? The judge could take away your gun. You don't need to be convicted. So it seems pretty similar, except going armed is different from having a gun in a domestic violence suit. So, but they're not like completely different. They're similar. They're relevantly similar, possibly. So this is up for you to decide. So you want to listen. Is this analog relevantly similar? And again, why does this matter? Because of democratic legitimacy. Because you want to know, the ultimate question is, would the framers approve of this one? This is the real question. Why do I care about question 2? Because I'm asking, do the framers approve of this law? But I can't resurrect them. So I don't know, I have no idea to know if they would approve of this law unless I just see what did they approve of back in the past. Henry, you have another question?
I wasn't sure if we could borrow questions from the recent Rahimi case about how dangerous a person is.
Ooh, yes. Yeah, so there's a case that's pending that this case is based on, and the hearing, I think, has already happened, but they won't release the decision until after the moot court season. So it's going to be really fun because we'll see who's right right after the moot court season is over. And you can borrow questions if you want from that case. Okay, anything else I wanted to say about that? Okay, any questions about the Second Amendment? Nobody. Everyone knows exactly. Yeah, go ahead.
Can you talk about the limiting principle? So is there a limiting principle, or is there isn't a limiting principle to the prefatory clause?
Oh, I don't think that the prefatory clause does limit. I think Heller would say the prefatory clause does not limit the operative clause. So the preface, where it says the militia, does not limit how you read the second. It just announces the purpose. That's what Keller would say. Yeah. Okay, I'm going to give you a quick point on the ballot, and then we will open it up for questions. So be preparing your questions in the meanwhile. Okay, so when you're adjudicating rounds, ultimately you're the judge, so you decide how you adjudicate rounds. I'm going to make a suggestion, but you do not have to take it. The easiest way to, in my opinion, adjudicate rounds is to go speaker by speaker and compare them to each other on each category. So as soon as the round is over, I'm going to think about my 4 speakers in the category of organization. Organization refers to how much time did they spend on each point? Was it like 1 minute on the first point and then 9 minutes on the second point? Did they like jump around from point to point? Did they not know how to answer your question in a structured manner? Those are the organization questions you can think of. And maybe you say the best person got a 9 because he was really good compared to everyone else. And one person was 1 point behind him and a person was 2 points behind him. That's an easy way to evaluate that. The knowledge point part of the ballot refers to how much case law and facts of the record they're aware of. So if you don't hear them quoting hardly any case law, that means that they aren't very familiar with the packet. So they haven't demonstrated that they have good knowledge. So that's, again, that's case law and facts of the record. And then the third category is argumentation. Here, you're really is kind of where you talk about persuasiveness. So remember I said that Smith should be overturned if there's special justification. One of the questions you can answer in the argumentation portion is, how persuaded was I by the case to overturn Smith? Did he persuade me? Dang, Smith was a really bad case. Or was I just like, I've heard worse. Like, that's the kind of questions you ask during the argumentation portion. Was I persuaded by his historical analog? Did he give good argumentation for that? Or was I like, meh? And again, you want to try to separate your bias here. And you want to try to just say, in terms of the overall persuasiveness of their argumentation, what was it? Okay? And again, you compare it relative to the peers, and you can compare it relative to everybody else, but it's easiest to do it within the round. So pick one person, and you're like, okay, their argumentation was the best. I give them a 10. The next person, they were like way worse. So I give them a 6. And then the other person was like a little better, so a 7. And then the last person was like an 8. Like, that's how you kind of do the argumentation. Response, what you're looking for in a response, it's pretty self-explanatory. It's when you are asking questions of them and they're responding to you, how satisfied do you feel at the end of your questions, at the end of their answers? Do you feel like they're addressing your questions, or are they kind of dancing around them? And this is not necessarily just argumentation, but also like, how succinct are they? How much knowledge do they, like facts of the record, are they pouring into it? In general, how satisfied are you by their responses? And then the fourth category is delivery. Here you want to look for slow delivery. You want to look for delivery that's not overemphasized. So good moot court is calm and collected. And the reason for that is that is a kind of an images and appearance thing. If you're appearing before the court of law, you shouldn't need to use persuasive tactics like hand gestures and super big inflections. Like, it's not a TED talk. You just need to tell them about the law. So in general, it shouldn't be, Your Honor, this, and this, Your Honor, and this, Your Honor, because that's too animated, right? That's not fitting in a court of law. On the other hand, it's possible that, they're too boring and they can take it the opposite direction. So you do want to kind of find the middle ground, but you do want to consider speech, how slowly they spoke, how passionate they were or overly passionate they were. Also, if they're reading from their script, consider that too, because that means they're not making as much eye contact with you. Those are the kinds of things you can consider in delivery. Okay, in terms of the actual mechanics, in terms of the actual, this is the wrong one. In terms of the actual mechanics of asking questions, you can ask 3 types of questions. You can ask open-ended questions. So you could ask things like, what do you define compelling interest as? Like, how would you describe a compelling interest for me? You could ask closed-ended questions. This is from last year's case packet. Like, couldn't this have happened? Or like, so for this year's packet, you might ask questions like, isn't there so much evidence that Mr. Mendax hit his wife? Isn't he practically a criminal? You could ask those kind of closed-ended questions. You can also make statements, because Supreme Court justices do this all the time. And if they can do it, so can you. So you could say something simple, like, I'm not really persuaded by that because I think this, period. You don't have to ask a question. Because honestly, it is a conversation. Now, if you just say, that's a bad argument, that's hard for them to bounce off of. But you are allowed to just make statements like, I don't think that's persuasive because of this, and just stop and see how they respond to that. In general, guys, you are the kings of the court. So they should stop when you ask questions. They should be respectful of you. They should never talk over you unless they're having internet difficulties, which happens, but they should in general not be talking over you. They should do their best to respond to your questions and not say, I'll address that later. They should, like when they're closing their speeches, they should try to avoid asking for extra time because that's disrespectful to the court. But they should never go over their timer by like 10, 15, 20 seconds. Those are the kinds of things. This is your courtroom, so you can dictate it however you want. Those are my general suggestions. Okay, it is time for a Q&A about anything and everything moot court. So if you have any questions about the packet, about any of the issues that we've covered, First or Second Amendment, about judging, about procedures, anything, I am ready to answer your questions. And it looks like Henry has a question to start us.
What do you think of the way Stephen Breyer asked these really long-winded scenarios? Do you see that happening? Is that useful?
Yes, hypotheticals are good because hypotheticals allow the mooter to think outside of the case. Okay, so for example, I pose some hypotheticals to you about a judge who's an old codger and he wants to ban hats in his courtroom. That's a hypothetical. Why does that matter? Because it matters about not just this case, but this case affects lots of cases. So you also want to know how it affects the other cases. So you could ask hypotheticals about polygamy. Do you think that polygamy, a law that bans polygamy, do you think that that would pass strict scrutiny? Or do you think that that is a good law that we should presume in favor of? Should we apply the strict test to polygamy or should we apply the easy test to polygamy? And they might say, well, we're not talking about polygamy. I know you're not, but I'm asking you to address the hypothetical. You can totally do that.
Is it unfair to say something like, if you don't overturn Smith, then us as homeschoolers might not be possible if they just, for the sake of public interest, require everyone to go to public school?
That is a fair question that you can ask. If you say us homeschoolers, they'll be like, man, a homeschooled Supreme Court justice. I never heard of that one before, but you can ask that question. I think it's a valid question. Yes, Mrs. Coe.
So this seems to be quite a bit different from what we've seen in the past several years, like with the Fifth and Eighth Amendment, say. So correct me if I'm wrong. So in the First Amendment, we are questioning justification rather than case precedents. Is that so? And in the Second Amendment, it's more historicity than case precedents. Is that right? I'm just wondering, in the past, we've been looking for their knowledge of the precedents, right? And here it seems like, you're overturning the Supreme Court case. There's not a lot of precedents to that, right?
Okay. I agree with you on the Second Amendment that you're not as focused on precedent as you are on historical analogs. So yes, you are more interested in listening to the history. And they can't use outside research, so they're just going to be citing you historical analogs from the cases that they read. So it is somewhat case precedent, but it is more historical. On the First Amendment, I actually think it's the reverse. The facts of the record are less important on the First Amendment. And when people say you should overturn Smith, they can't just say, well, I think it's a bad case. They've got to show you why Smith was wrong, which requires them to be experts on Smith. So they've got to know Smith referenced Minersville School District versus Gobitis, and that case got overturned like 3 years later in Barnett versus West Virginia School District. They've got to know these facts, or they've got to say, Smith quoted this other case before, and that case actually lines up with Smith. So Smith was a pretty good case because of that. And when you read the past cases, it'll tell you if Smith was in line with those past cases or if it was out of line with those past cases. So there's a lot of precedent this year on the First Amendment with Smith.
Okay.
if they chose case number 2, which is not overturning Smith, there will be less precedent involved. But yeah.
Thank you.
Yes. Let me see some of the questions in the chat. So Dylan West says, on footnote 4 where it says psychological dependence, is that a typo? Oh, yes. It is a typo. It should say psychological dependence. And then Henry has a question, how do you recommend judges prepare for moot rounds? Okay, so I mean, this is up to you guys. So if you're really interested in these materials, you should feel free to read the case materials, like the case law. And like, if this interests you, go for it, because it'll make you a more informed citizen. Do you have to read case law to be a good judge? No, not at all. In fact, what I've presented to you, hopefully is enough for you to know what's going on with the rest of, with the round, so that you're not completely lost when people mention overturning a case like Smith. You know that case was a controversial case that usually made people with religious exercise lose. So you can research as much as you want within the packet, read the packet. What I would recommend, ideally, before you go into the round, is at least read the facts of the record, and it's 5 pages. That's pretty easy, so that you're familiar with exactly what goes on. And then you can also read the bench brief, which I have, which NCFCA offers on the resources tab. And you can access that, which will help you get a little bit more, a second kind of pass through on all of the details we've discussed today.
No, if there's.
Yes.
Yeah.
Oh, sorry. Is there, like, you know how in TP there's sort of this concept of like 2AR abuse? Is there the same concept with the last rebuttal in moot court?
This is a very interesting question. I'm glad you're thinking about this. Yes, there is. It is not clear, and the same thing is kind of true of 2AR abuse, because you can't really like compliance somebody for saying an argument you didn't like just because you thought it was 2AR abuse. It is kind of difficult. So that's why the more informed you are, the more you're aware of people using 2AR abuse. So the best way to combat it is for judges to be more aware of the facts of the record and the case packet, so that people can't get away with saying things that aren't true. One way in which, so I say that to say, like, you should not really be taking people to compliance for 2AR abuse. You can adjudicate it in your ballot if they said a fact that was incorrect and you look it up in the packet and it's wrong. I mean, that you're the judge, so, and you have access to the packet. They're supposed to know the packet backwards and forwards. So one thing to look out for is, for example, some people, so there's a bifurcation. You could say that this case is only the individual, or it's for everybody, the entire law. In legal terms, we say it's as applied, which is like as applied to this person, or facial, which means the face of the law. On the face of the law, it's wrong. Both challenges this year are facial challenges. So they are not for the individual. The individual will be affected, but it is challenging the law. The Paladosa law that bans psilocybin, and the Paladosa law that says that if you're a PO subject, you can't have a gun. They're challenging the law. So if somebody in the rebuttal stands up and says, well, we aren't concerned about the effects of everything else because really we're just talking about this one individual, you can tell them that's not true. And the respondent will be crying tears of joy if you say that to them, because they will be crying behind their cameras about how their opponents are lying about the case packet. So this is why I'm saying, like, the more familiar you are with the packet, the better it will be for them. But don't worry about it, don't stress about it. Other questions?
So I've got a couple of questions. I guess I'm not sure what everybody else's background, but we're kind of newbies in that we've never done anything moot court. So our experience is solely TP, LD, debate. And so we understand the structure of the debates and how they take turns and all that. But we haven't done the homework, I guess, yet to understand the structure of how this works. Is it similar? And how do we control the flow of it, or is it all directed by them and we're just a participant?
If you watch the moot court training video, it will tell you everything you need to know.
Okay.
But that includes it goes petitioner, respondent, respondent, and then petitioner rebuttal. And you do have some speaking roles. So you get to play out a Supreme Court justice announcing the case. So you're going to say, the only case on the docket today is Toby Mendax versus the state of Paladosa. And then you're going to say, is the petitioner ready? And they'll say yes. Is the respondent ready? Yes, you may proceed. You can say all those things, but you'll see that in the training video.
Okay, great.
You have another question? Okay, Henry has a question. Can kids bring in the concept of facial versus as applied? Kids should know facial versus as applied. They probably won't need to mention it because everyone should know that these are both facial challenges of the law. They're just challenging the law. And then hot versus cold benches. In general, students much prefer having conversations with you guys. So they much prefer you asking questions. Even if you don't know what's going on, if you ask, could you explain that again? Or if you ask, how would you respond? Here's my favorite thing. Like, students will love you if you are writing down what they say and ask it to their opponents. Because that allows them to interact with their opponents, even though they're not supposed to be doing, line by line refutation. If you say, your opponent made this great point about how Smith is a bad case because it misinterpreted the text. How would you respond to that? Do you think it misinterpreted the text? That way you don't even need to be doing that much hard work because you're just listening to what they're saying and then passing it off. But in general, students really love questions. They do not think that there are dumb questions because if anything, quote unquote dumb questions allow them to explain the case law to you, which makes them feel smarter. So do not feel bad about asking questions. In fact, you should feel bad if you ask no questions. So
yeah, my kids have explained that they much prefer hot benches, even though they might seem aggressive. It allows them to play back with the judge. But one follow-up question I had was this idea of responding, could you respond to the petition argument? Could you respond to respondent arguments? One thought, I just want to hear your thoughts, is either I could surface it and set it up, a clash, or I could keep quiet and say, will they bring it up or not? Or will they keep their own script? And then I'll dock them points if they don't respond to the petitioner or respondent.
Yeah, so you have to keep the balance between they should be interacting with their the other counsel's arguments while it's not really debate. So it isn't a refutation, line by line refutation. There are small instances, but it's not usually a dropped argument kind of thing where whoever has the most arguments wins, because that just makes it debate. And moot court, in real life, this is how moot court works. The attorneys submit briefs where they have like 100 pages of their argument. The justices read all of them, and then they just ask some questions at the tail end to clarify some things. You don't have the advantage of getting the 100-page brief, so you don't know what they're going to say. But I say that to say you should not expect them to have the equivalent of 100 pages of arguments. You should not expect them to respond to everything that their opponent says because they have 8 minutes, 10 minutes. You should expect them to adapt a little bit, because if they're just reading from their script, then that means that they're not very adaptable. But it should not be, my opponent said this, I say this. My opponent said this, now I say this. My opponent said this. That's just debate. In fact, the most professional way to address your opponent is not to call them your opponent, because I've never heard an attorney say my opponent in my entire life. And I've been to many trials. You always refer to them by their last name, or by counsel for petitioner, counsel for respondent, or by my colleague on the other side, because they are your colleagues. You work with them all the time to make sure that you get this case solved correctly. Don't let them slip into debate mode. It is best if you keep things professional. So they should be calling them by each other's last name or counsel for petition. Okay. Any other questions?
So Ethan, are you, you mentioned earlier about taking notes or whatever. You had some great drawings and stuff. Are you gonna push those out, or?
Sure. I can share my notes from my Remarkable. And I also, so in terms of resources, I'm working on a question list for parents. So Moot, the judging packet has some suggested questions. As I'm working with students, there are some questions that I'm figuring out are better to ask. So I will also have that list available. So if you're interested in that list, you can email me and I will send you that list. The recording of this lecture webinar will also be available, assuming that the recording pans out. And so if you would like that, or to pass it off to anyone you know who's interested in judging, email me also, and I would be happy to pass along the recording. And then I'm a Blackstone coach. So if you are interested in receiving any coaching, the website is blackstonemoot@webflow.io. So I will put that, I think it's in my email tag anyway, but if you're interested in coaching, I do offer some coaching. So,
and if for those of you who have not ever used Ethan, he is wonderful and very helpful for the children, and it's really, he's a fantastic coach.
appreciate that, Lee. Okay, if there's nothing else, anything else?
My son Christian uses you, Ethan. He really enjoys it.
I'm glad to hear that. I enjoy working with Christian. He's great. Yeah. Okay. Well, thank you very much for your attention. I know this was a lot of information, so take a deep breath. And if you don't get it all, that is totally okay. If you need to watch the recording, just send me an email. I'm also always happy to just answer questions over email during the season. So if you're like, I don't understand this question, or how would you respond to this? Feel free to email my Blackstone email that you have been receiving emails from. But thank you to Heather Newman, Lasting Impact, all of you guys, and your attention. I have really enjoyed speaking with all of you. So have a great rest of your Tuesday. I'll see you later.
Thank you.
Thank you.
So much. Thank you.
Thanks, Ethan.
Thank you.